Welcome to the ISO Show, dispelling myths and sharing tips for success to improve your business with ISO standards.
Do you currently hold certification to multiple ISO standards? Are these being operated as separate systems? If so, you are missing out on the many benefits that an integrated management system approach can bring. For those looking to create a more holistic view of their quality, risk, and environmental management, we have just the webinar for you. Join us on the 26th of September at 2 p.m. BST for our webinar, From Silos to Synergy, the benefits of implementing an integrated ISO management system, where we'll be covering what is an integrated management system, the compatibility of ISO standards, the benefits of an integrated approach, key considerations ahead of integrated management system implementation, how to integrate ISO standards, and a Q&A session. Attendees will also get access to some exclusive offers, so don't delay, register for this free webinar today. We look forward to seeing you there.
Hello everybody, this is Ian Battersby again, Senior ISO Consultant at Blackmores UK Limited. Welcome to another ISO show, the latest in a very long line of shows where we try to give you a bit of insight into the world of ISO standards and specifically management system standards. Today I'm going to talk on the topic of the many ways of evaluating compliance. Regardless of which standards you use, all organisations have a duty to demonstrate compliance in some way or another. It's not just part of running a management system, it's part of running any business. And I use the term business broadly, of course, that 9001 clarifies this term as being activities core to the purpose of an organisation, whether that organisation's a public one, a private one, for profit or not. So business is a term used in the standards, which it means more about how the organisation operates than anything else. Before I get fully started, let's talk terminology. Anyone who knows me or has listened before may understand why misuse of terminology irks me so much. Let's talk about the words conformity and compliance, because today we're talking about compliance. They may appear to be the same thing, but there's a clear distinction between them. You can't comply with a management system standard. You conform to it. That's how you get a non-conformity. You don't get a non-compliance against a management system standard. And no matter what some people put in their audit reports about non-compliance, that's not what you get. But you must comply with the law. And all the standards make this distinction very clear. So what is the law? Let's get on with the boring bits about what laws are. What are legal requirements, as they're termed in some standards. I'll talk about the UK. That's what we know here as a team. That's what I know. In the UK, we have different sources of law. But what I want to concentrate on is what we call statute law, legislation, as distinct from common law, case law, and constitutional conventions. They're other aspects of law, but these are laws which are written down and made through formal process, okay? Unlike some other aspects of law in the UK. They're the sorts of things you can easily record in your legal register, or register of compliance obligations, as it's sometimes called. And there are different types of legislation. Firstly, there's primary legislation made by acts of UK Parliament and, to a certain extent, acts of the devolved administrations as well. These are also called statute. So statutory compliance refers to compliance with primary legislation. So you'll see statutory compliance mentioned quite regularly. And for example, one many of us are familiar with is the Health and Safety at Work Act. So that's clearly an act of Parliament. But laws often require a lot more detail regarding the practicalities of applying them. These sorts of details, these practicalities, are not easily considered through the parliamentary consultation and lawmaking process. They're delivered under secondary or delegated legislation. They're generally known as regulations. Some are more detailed and targeted mechanisms and called orders, but we tend to talk in terms of regulations mostly. These sorts of regulations are made by ministers or their government departments or public bodies and the like under powers which are delegated under an act. And there's another piece of terminology here. Most regulations are issued under what we call statutory instruments, SIs. And these are the formal legal vehicle that gives them effect. So regulations are the rules, statutory instruments are the legal mechanism which brings those rules into effect. So if you look at an example I've just talked about, the Health and Safety at Work Act is quite a broad, generic act. And the government, some years later, made the Workplace Health, Safety and Welfare Regulations and also the Management of Health and Safety at Work Regulations, which both came into force via statutory instruments. Okay, so those regulations weren't written by passing another act of Parliament. They were developed through consultation between government departments, other bodies, the Health and Safety Executive and the like, who came together to create these things, which Parliament just would not have the ability to sit and consider. So you've got these different forms of acts and regulations. And you've also then got different regulators. It's not just the police who enforce legal requirements. You've got a number of bodies which are independent of government and the judiciary, and those bodies can enforce regulations and prosecute breaches by organisations and individuals. You've got bodies I've just mentioned, the Health and Safety Executive, HSE. If you work in the financial sphere, you've got the Financial Conduct Authority. You've got the Environment Agency, which oversees environmental protections. You've got the Information Commissioner's Office, which looks at data protection and privacy. So there are all sorts of different bodies, and businesses must comply with both the general laws, such as Companies Act and employment law, and the specific regulations which apply to their type of activities. Okay? If you've listened before, we often talk about interested parties, which is one of the initial parts of any of the standards. And these interested parties must be determined as part of Clause 4, it is, of every one of them. These types of regulators, HSE, Financial Conduct Authority, Environment Agency, whoever, are the types of parties you should consider when addressing this clause, because they're the types of bodies who enforce regulations over your particular business. So they're important. They are very interested parties on occasion. So as I said at the outset, regardless of the standards, which standard you're using, all organisations have a duty to demonstrate compliance with laws, regulations, in some way or another. It's not just part of running a management system, as I said, it's part of running business. But of course, certain standards do have requirements in them. If you take, for instance, the Occupational Health and Safety Management Standard 45001 under 6.1.3, it's about the determination of legal requirements and others. Leave others for a moment. 14,001 calls it something slightly different. It talks about compliance obligations. But they're about the same thing. Both of them say that you need to determine, and then have access to the compliance obligations and legal requirements which affect your organisation. And then you've got to determine how those obligations apply to your organisation. So what do they mean actually to you? So don't just say, yeah, we've got an act here, we've got a regulation here. You have to understand what that means in the context of how you manage your business. So the requirement in some ways is sort of codified in the standards. So it points you towards what you should already be doing. And that spans all jurisdictions, whichever country you operate in, you are required to, stick to and comply with the legislation in that country. but also under standards like 14 and 45,001, you're also required to. Even 9001 has in its introduction, there's clause 0.1 that it talks about the potential benefits to an organisation of adopting a quality management system based on that standard. One of those potential benefits is to be able to provide products and services that meet the customer and applicable statutory and regulatory requirements. It goes on elsewhere, in the understanding the needs and expectations of interested parties. I've mentioned that already. Because of their effect on the organisation's ability to do things and its ability to meet statutory and regulatory requirements, the organisation's got to look at interested parties. So those regulatory bodies are important again there. And even under customer focus, which is part of the leadership clause, leadership have got to show their commitment to sort of meet all customer requirements, but also any applicable regulatory and statutory requirements associated with the product and service. That phrasing is repeated throughout 9001 and specific throughout operations. You need to design, build and deliver things which meet statutory and regulatory requirements. And then when you look at environment and health and safety, both of those require an evaluation of compliance, both as part of monitoring and measuring, and the results of them to be submitted through your management review processes. So there's all sorts within the standards about the evaluation and reporting of your status with respect to compliance. What's interesting here, though, is that the standards are very, very clear in that you have to determine the frequency and the methods for evaluation of compliance. So you have to state how you're going to do it and how often. And there's a guidance piece in 45,001, there's an appendix to it, Appendix A, and within that monitoring and measuring side, it does say the examples of what could be monitored and measured are the evaluation of the fulfilment of legal requirements. Okay? And whether you have met all your legal requirements and whether you have documented information around that which is kept up to date. Now, this is really important. Often we see a legal register which states that for every entry that its compliance status will be evaluated in an annual internal audit. So, okay, great. How can you demonstrate that you've kept records and compliance up to date by having an audit at a fixed moment in time, once a year? You can't demonstrate that you've determined the appropriate frequency and methods of evaluation by a broad brush. Let's do it all once a year. So you're immediately at risk here of falling foul of the standard in two parts because you can't demonstrate up-to-date record keeping or that you've determined an appropriate frequency and method. Plus, once a year, particularly for a larger organisation, is an incredibly burdensome exercise. If you've got health and safety and environment and other legal requirements, and you're trying to go through all of their requirements once a year to demonstrate that you have evidence that you meet your obligations to those, that's terribly difficult to do. It's a very onerous administrative exercise. And this is really important. If you discover non-compliance against a legal obligation after the fact, what will you do about it? How do you make yourself compliant in that circumstance? And let's take a practical example. Let's look at waste removal. We all have to remove waste. It's something we do, whether we do it ourselves through directly contracting a waste management contractor or whether we have a landlord do it in a tenanted building on our behalf. The law states that waste which you generate must be removed, transferred, processed, treated, whatever, by a licensed organisation in a very specifically regulated fashion. Now, you as an organisation or your landlord may receive an annual season ticket which includes the required demonstration of compliance or seemingly the required demonstration of compliance. Now, that could be the waste carrier licence number, the types of waste, the classification codes under the European Waste Catalogue, dates, signatures, all those sorts of things may look good. Let's say you receive one of those season tickets for 2025. It runs from January the 1st to December the 31st. Okay? all looks above board. Let's say you do an annual audit of compliance in September each year. That's what you do. You state in your legal register, we will do an annual audit in September of all legal compliance obligations. And let's say that you find something wrong with the season ticket and that all subsequent waste transfer notes which were provided for each pickup have been wrong on the same basis that the season ticket was wrong. For example, you might have identified the wrong streets. You might have the wrong codes. You might have a license expiry in the middle of the year. You may have, for example, this year, a change in requirements due to the simpler waste guidance, where food now has to be segregated, which has not necessarily been identified on the 1st of January. So what do? Your audit is of no help here in demonstrating that you've done the right thing after a certain point in time. It just tells you that you haven't done the right thing. What will you do now? How do you rectify that as a non-compliance? How do you make yourself compliant for that period of time? You probably don't. You have to make yourself compliant going forward. Your legal register, if you call it that, should reference that you've evaluated that the season ticket complies with waste regulations at that point, and that all subsequent transfers therefore have also been documented accordingly. So you put this into your legal register. You have evaluated the season ticket and subsequent documentation. Your records of this compliance should be gathered and saved as they're created or received. Okay? So contemporaneous records created at the time of the event. They should be readily available. Electronic would be good. If you store these in a shared folder, SharePoint, a document library, something like that, okay, then your register, whether that's a spreadsheet, a database, a SharePoint list, a proprietary system, even your ERP or whatever it might be, you can include in that register a hyperlink to the location of that evidence. You don't need an annual audit to say that that evidence exists. You are constantly linking to the location of that evidence. You can audit in the future to examine the sort of veracity of that, but it's that simple. You have an ongoing record. Another example, you have aircon. It requires an annual service. Let's say that happens in March, okay? You're still doing your annual compliance audit in September. Okay. The contractor which sends the engineer must be verified before you engage them. They have to be competent under F-gas regulations and hold, here in the UK, a REFCOM registration, as we call it. They must be able to show you a certificate. I even referenced the REFCOM registration online to show you that they are compliant with that registration scheme. But under a separate F-gas competence regulation, the individual who attends your site to do any works on refrigerants must also have valid personal certification, that they've done a city and guilds or something of that nature. If you wait until September to evaluate compliance and discover that there's no valid certification for the company or the individual, for instance, let's say that they sent through last September their certificate because you audited last September, but that certificate then ran out in December and they attended in March. Can you verify that that organisation is competent under the regulation? Similarly with the individual. Also, with the individual, did you verify that the individual that you had seen the competence information for was actually the person who turned up or the people who turned up? Okay? So, if you don't hold a record at the time things happen, how do you demonstrate the compliance aspects of that work? Do you have to go back and get your aircon reserviced by a competent body? I don't know. Again, your legal register should reference that you evaluated the contractor, okay? Evaluated that they're competent under the requirements of the F-gas regulations, and also verified that they're competent at the time of works. So copies of the cert and the registration number and checked before they arrive. You should have similar for each individual before they arrive and a verification that that person attended. Any report of the works should ideally have such data included, so REFCON numbers, names of personnel. Okay? Now, your records of this compliance should be gathered and saved as they're created and received. They should be readily available, as I mentioned before, and if you store them in a shared place, folder, SharePoint, whatever, then your register can include a hyperlink to the location of that evidence. Simple again. And that evidence as it happens. Okay? So contemporaneous record keeping is an absolute key to ongoing evidence of compliance. It makes life easier for you. Yep. If you look at something like the Health and Safety at Work Act, it can be very difficult to demonstrate overall compliance. It's just too vague. Like I said originally, acts are quite broad, but you can still be prosecuted under that act. And this is where the detail in regulations helps us. You can use something like the Management of Health and Safety at Work regs to apply the detail and provide concrete evidence against its individual requirements. Much more difficult than trying to apply it to the Health and Safety at Work Act. But again, it's very hard to pick a specific point in time and say, this is the day we'll assess it. Because there's so much in it. And there are so many things which happen all the time which need to be checked. Okay, so let's look. The regs require us to carry out suitable and sufficient risk assessments, say. To identify hazards, assess risks, determine control measures, communicate those to people, make sure they understand. It requires us to review those assessments regularly or if circumstances change. So this may be a rolling programme. Now, it would be sensible to list that rolling programme of risk assessments. So when do they happen? When were they issued? When are they due for review? When have they been reviewed? Okay? Your legal register can then reference that you've evaluated that the required risk assessments are in place by hyperlinking to that list. The register and or the list of risk assessments could point to the document library, shared folder, SharePoint system, which has the actual risk assessments for viewing. So the evidence is there before you, linked directly from the legal register, compliance obligations register. Okay? As part of the management regulations, you're also required to have health and safety arrangements. How does your legal register demonstrate this? Arrangements is great. It's all very fine. There's documentation which you must provide, policy, procedural documentation, which demonstrates to an extent that you have arrangements in place. And they can be easily referenced. So again, your register can go, there's a hyperlink to policy. There's a hyperlink to the roles and responsibilities. Our organisational arrangements are reporting. But it's more difficult to demonstrate that your arrangements as they're written down actually work and that your workplace is actually safe. So you may have, and this is a good way to do things, a programme of workplace inspection. It doesn't have to be particularly detailed if you're a low-risk environment. It might be a lot more detailed if you're an industrial complex. Your legal register could link to that programme. So here's all the dates at which we inspect our different pieces of property, our different facilities. You could link to the programme, then to the actual reports that the programme is being fulfilled, and to the list of their findings and recommendations, and the actions that you've put in place to rectify any issues you've found in those inspections. Now, those inspections may include specific risk issues covered by other regulations that might pertain to fire, personal protective equipment, lifting, heights, welfare, waste, again, electricity, all sorts of things covered by specific pieces of legislation which may or may not be relevant to you and in your legal register. Most of those could well be. You can use such a tour, such an inspection, to evaluate compliance against a whole host of these different requirements on an ongoing basis. Then hyperlink from that requirement in your legal register to show that you've evaluated through copies of the reports that you've completed during those inspections. So that's a very easy way to cover all sorts of different things not through an annual audit which discovers you haven't done what you need to do and you're struggling to find the records, but through ongoing personal conducting of tours and inspections and talking to people and looking at records. And by carefully constructed either folder systems if you want them, or document libraries, but readily available information of which is documented at the time things occur. Another thing that may require documentation as it occurs is something like if you require an environmental permit for emissions, discharges, whatever. You should keep a record of the permitting as it's issued to you, so you know it's correct at the time of issue, and any copies of your own analysis and reporting and returns which are made under that permit. Again, if these are stored in a shared place and readily available, hyperlinks can be established to where they are, and your legal register can easily link to those to show that your evaluation of compliance is ongoing. Don't wait till September to find that you've breached your permit. Now, just some examples there. There are all sorts of ways of measuring what you do to show compliance. Audit is a valid way of doing it, but putting all your eggs into an annual audit of compliance is a very difficult way of doing it, and it doesn't allow you to go back after the fact to demonstrate compliance that you may have been weak on originally. Inspection, as I've mentioned, is another way of doing it. You may have sampling and analysis. Legionella, for instance, you sample and analyse water on a regular basis. Those records are important. You can't go back and recreate those records if you didn't store them at the time the sampling analysis was actually performed. Maintenance and servicing is a very good way to demonstrate compliance. Linking to your maintenance and service records, as I've mentioned, can demonstrate that you've verified the competence of external contractors coming in, but it also shows that you have equipment, machinery working optimally, working safely, working in line with regulation on occasion. You may have industrial processes which require permanent inline monitoring of that process, which provides data on a constant basis or at least regular basis, which is recorded. You can link to that data. You may have to calibrate equipment, and through that calibration, you demonstrate the conformity of that equipment to standards and, on occasion, to legal requirements. So those calibration records can also provide evaluation of compliance. You might have a meeting. You might have governance arrangements in place which demonstrate that you've reported the types of things that you should report, that you've taken management action over the things that you ought to have taken action over, that you understand your level of risk, that you understand your profile of hazards. So meetings and records of meetings and minutes of meetings and actions which flow from meetings are also quite important, particularly if you're trying to demonstrate arrangements. So there's all sorts there. We could go on again as I normally can do, but I hope I've given you an impetus to not sit back and think, oh, next September we'll do that audit again, which will take us 3 days, and we won't have the records we need because we didn't keep them in the first place. By doing it as an ongoing exercise, by having readily available contemporaneous information, and by using the power that we've got of hyperlinking documents and libraries to each other, you can make life an awful lot easier for yourselves, but also demonstrate to any bodies which might have a need to enforce that you have done the best that you can to meet your compliance obligations. I hope that's been useful. Thank you again for listening. Before I go, can I just remind everybody to subscribe on your preferred platform, your preferred media player, if you've not already done so. And if you get a few minutes to spare, only takes a moment, please give us a nice review. 5 stars would be fantastic. The review process does help us to reach a wider audience. As always, if you have any questions, please get in touch. Ask us anything you want. But also if you've got suggestions for future topics, it's all very well us coming up with ideas, but we want to know what you want to talk about. So just email us put it in the comments section on your media player. We'd love to hear from you. So that's all from me today. Thanks again for listening, and we'll catch up on the next ISO show. Thank you. Goodbye.
Looking to use ISO standards to drive better business practice? Contact us at blackmoresuk.com to access further information and book your free 15-minute call.